Good afternoon. I've got that it's just now 2 o'clock, so we'll go ahead and get started. Welcome and thank you for joining us for the June session of our Community Associations Building Blocks webinar series. Today's session will cover the topic of privacy and data security. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Ward & Smith, and I'll be your moderator this afternoon. If you have any questions with video or sound quality during the presentation, please reach out to me via the Zoom chat feature and I'll try to troubleshoot with you. Our speakers are happy to answer questions at the end of the presentation. If you have a question at any time during the presentation, please type it in the Q&A box. Now let's get started with introductions. Today's speakers are Angela Dowdy and Peter McClellan. Angela is a North Carolina State Bar Board Specialist in Trademark Law, who also serves as the firm's Director of Legal Innovation. In her privacy and data security practice, Angela advises clients on all aspects of privacy and security regulations, including evaluating and implementing compliance programs, responding to data breaches and security incidents, drafting privacy notices and policies, and negotiating consumer and vendor contracts. Peter is an attorney who assists clients in a range of privacy, data security, cyber supply chain, and technology matters. He regularly counsels on the legal requirements and risks associated with the collection, storage, transfer, use, protection, and disposal of data. Businesses and individuals rely on his privacy and data security expertise for structuring and operationalizing, privacy compliance programs, data breach response and planning, contract and vendor management, and licensing and technology transactions. Angela and Peter are both certified information privacy professionals. Now I'll turn the mic over to Angela and we can begin.
Good afternoon, everyone. Thank you so much for joining us for the privacy and data security portion of the Community Association Building Block series. As you've probably seen in the news lately, there is a lot to data and privacy and a lot of misconceptions. So we thought we would start from the beginning. And Peter, for those that are new to this topic, what exactly is privacy and data security?
Yeah, so in today's world, just about every organization is going to collect and use people's personal information for something, whether it's to communicate with stakeholders or to promote an event or a service or to figure out who's paid their bill and who hasn't. But there were a series of data breaches that exposed just a ton of personal information to criminal actors who then used it to steal identities and commit fraud. And a lot of governments started regulating how that information can be used and how it has to be protected. So at its core, this area of law today, privacy is the law around how an organization is allowed to use and collect personal information, and data security is the law around how organizations need to go about protecting it.
So going back to the news, it's just huge companies, right? Like Equifax, Facebook, they're the only ones getting in trouble for privacy rules. At least that's what we're seeing in the media. Why do community associations need to worry about these types of regulations?
Yeah, it's very much not just the big folks like the Equifax and the Facebook. So in getting ready for this discussion, I actually took a look at what my family's HOA collects on my family in order to do different things throughout the community in the various different forms they have us fill out. So whether it's to register to pay our fees, to get access to the pool, to use the gym, anything like that, they collected our first and last names, our address, birthday, our HOA account number, home phone, mobile phone, work phone, bank routing number, an account number, and our email address. So plenty of community associations or their management companies require or strongly encourage their residents to create an online account for updates, chat rooms, easy payment options. Those accounts require a lot of this information and it can be very sensitive. And how that information is used is often going to be subject to legal regulation. That information the information that's in these accounts could be just the bare bones of what they need to operate, name, address, payment information for dues, but also usually has data like emails and phone numbers. Those aren't strictly necessary, but they make life a lot easier for everybody in the HOA. But at the same time, when you're collecting that information, the community association is taking on additional responsibility that they might not be planning for. It's also going to have an impact on the association's relationship with some third parties like its management company or any payment processors that they have. And it'll definitely have an impact on the relationship with an insurance company. So any kind of partner or vendor that the community association has that gets entrusted with residents' personal information, they'll often seek to establish expectations with regard to privacy and data security in those contracts. And they may even be able to shift the burden of risk depending on the terms of those types of agreements. So it's definitely going to impact more than just the big guys that'll make headlines.
All right, well, let's talk about that a little more. Most communities have these types of contracts. I know my homeowners association has these types of contracts with vendors. What should these management and homeowner associations be looking for when they're entering these vendor agreements and to protect themselves?
Yeah, so with their current contracts with, for example, a management company, the management company is often going to want to shift the burden of risk to the community association for anything that has to do with the data of that association. Third-party payment processors are going to want to shift that in the same way, or at least share that kind of responsibility for safeguarding financial information. And particularly with insurance providers, what's keeping a lot of them up at night, a lot of insurance professionals, is on the topic of cyber liability insurance. When an organization takes actions that the people in charge don't necessarily even know are going to be opening them up to possible liability. So the premium for an organization that can document their privacy and data security plan will tend to be much different and much lower than the premium for an organization that hasn't done much kind of foreplanning or preparation.
Yeah, so that reference to not knowing what is being collected to create risk, it does remind me of something that happened with my condo association, in which we had a board member that for a period of time was in charge of making sure that special assessment checks were coming in. And because he wanted to have proof, before he deposited the checks, he actually made photocopies of all the checks, and then he kept that in his file. But that then also meant that our association was collecting and storing, not just names, addresses, but now they also had bank routing numbers, account numbers, and honestly, with this individual, they didn't know it. So, if he had anything other than, noble intentions, or, if the discovery had been less friendly than another board member, it sounds like that could have really caused some liability issues for our association.
Yeah, absolutely. And because these laws, they don't really take account of whether an organization knows that they're collecting information or not. It just matters whether they're maintaining it. So all of the laws that would apply to a data collection that's done deliberately, intentionally, those laws are also going to apply to data collections that are unintentional. But obviously you can't have a privacy and data security plan for collections that you don't know your organization is doing.
So what are some other examples that typically come up that, our associations need to be aware of and on the lookout for?
Yeah, there are a ton. So just off the top of my head, if residents have a fob to get access to a pool or a gym, and there's any kind of log that can keep track of who's going in and out, that's geolocation data, and it can be subject to regulation. Even something like if you have an architectural committee and they have information that just kind of addresses someone's personal tastes under some laws that could be personal information. It'll depend on what law applies, which will be determined by where the individual actually lives long-term, but it could be personal information. If someone or anyone in the community requires some kind of religious or disability accommodation at association meetings, that'll be personal information, and sometimes might even be held to a higher standard as quote unquote sensitive personal information. And any of those three, I can envision falling outside of what an association leadership team would have day-to-day supervision over.
So even though there's all these regulations and, there are bigger targets, why would a criminal want this information from a homeowners association? What's the value here?
So it's not just to sell, though certainly a good amount of the information they do hope to sell. And it's certainly true that there's some information that's going to be much more valuable for criminal actors than other information. Financial credentials, bank account numbers, anything like that. Those could all be sold by criminals, sometimes for hundreds of dollars a piece. So if you have 1,000 residents who have signed up with their bank account number, 1,000 times hundreds, that gets very profitable for a criminal organization very quickly. The same might not be true for just run-of-the-mill email addresses, but what these criminals are after more often than not is not just the ability to sell, but also to cause disruption to an organization by locking an association out of their systems entirely, with the knowledge that then the association is going to receive a demand for payment. It'll be called a ransom. And the association is going to be tempted to, in exchange for the safe return of their data, pay that ransom. Once the money goes through, sometimes they'll get the data back, sometimes they won't, but regardless, reporting obligations for the organization have usually been triggered at this point, and the legal and economic damage has already been done.
Economic damage is always an interesting topic, because I think that the point gets missed many times when you're talking to an attorney just thinking about the legal consequences. So if a community association gets hit with an attack, what's the typical, or what's being reported as the economic damage for this outside of legal requirements?
Yeah, so you can get huge numbers just if you look for the averages across the board. I'm not sure how helpful that is by itself with the averages, because some of those are huge companies, some of those are sole proprietors. But what was very helpful recently is the latest study we've had on data breaches broke down the costs per record that you keep, so you can kind of scale it up or down based on the size of the organization. And they found that the all-in costs of a data breach, so not just the legal compliance costs like you were talking about, but also getting systems back working again, IT professionals to come in and fix the vulnerability. Everything from start to finish, the cost per record was around $146. When I went through the information that my HOA was collecting in various places, I came up with at least 10 records. That was the name, the address, birthday, my HOA account number, home phone, mobile phone, work phone, bank routing and account number, and my email address. So 10 times 146, that means per resident that they collect all of that on, they're looking around $1,460. So if an association has a 300 unit neighborhood with an average of around 3 residents per unit, that's 900 residents. Multiply that by 1,460 and you get a little over $1.3 million in expected all-in cost for the breach, even, for a community association. And that might seem astronomical, but remember, this is based on the data that we have. And so even if they're only collecting half as much information of what I listed out, just looking at what my HOA was collecting, half is still over $650,000 in all-in costs. And so it can get up there in a hurry.
Yes, that sounds like it can get very costly very quickly. So what other considerations should be given on the, the legal side?
Yeah, I didn't, and I'm not trying to diminish the legal side of the equation because, privacy laws apply based on where you reside. And so a typical HOA might only have 2 or 3 states that they need to comply with. When a breach occurs, the state that they're actually in, but then maybe 1 or 2 others for investors who have bought but don't live in the community. But a community association that has a good number of vacation homes or investment properties, you could be looking at 24 states pretty quickly if those different laws get implicated, because it's dependent on where the person resides. And one of the biggest cost drivers comes from not having an incident response plan that lets an organization hit the ground running when a breach occurs. If you have a breach and need to start from scratch, it will necessarily cost you more.
So if an association has vacation homes and we've got, several different states implicated, what is the typical requirement? What are we looking at for those 50 states? Like, why is it so expensive?
Yeah, so we don't have all-encompassing federal law. There have been debates on whether to have one, what it should include, whatnot. The bottom line is we don't have one standard across the board. So at this point, all 50 states have laws that require notification be made to the person whose information was held and breached when certain circumstances are met. And those circumstances will vary depending on what state you're in. Many will require an organization to let the Attorney General or some other head law enforcement officer in the state know about the breach. And a lot of contracts will have reporting requirements that can vary depending on the vendors. So if an association on the beach has owners' information from Ohio and Illinois and New York and Colorado and North Carolina, they may be obligated to meet the requirements of all 5 different states. And God help them if there's a European Union citizen who owns a condo in their community, because that one's a whole nother level of trying to get a lift on complying with that law.
So since it sounds like there's a lot of potholes that associations can hit, but it's that's a broad reach for 50 states or the European Union. What kind of guidance could you provide an organization to at least avoid these issues?
Yeah. So while we don't have a federal law across the board requiring certain requirements and preempting the states, the federal government has put together a good number of voluntary programs that will bring other technological, administrative, physical protections to information. The most prominent of these will have an organization map out the data that they're collecting and storing, put together a plan for protecting data, put together a strategy for detecting any kind of a breach, and then plan your response and build recovery and resilience into your efforts. It can really cut down on the cost when a breach happens. And some authorities have said openly that aligning with those federal policies, those federal voluntary policies, will help an organization if they ever have to come to court and say that why they were reasonable in their efforts in protecting data, because that's going to be the standard that most states will have you have to prove, is that you took reasonable efforts to protect it. And aligning with those federal programs is really strong evidence that an organization had done what they needed to do.
So if you could pick 5 things that everyone listening today could do, and I know it's hard to only pick 5, and before I even kick the question to you, I did see a question come through, and I actually love the question. So
Okay.
The 5 are going to be, Peter, I know, has 5, and there's a question that says, why would an association need your birth date? And the reason this is my favorite question, and one of the steps that I would say that it's not a legal step, which is what Peter's going to talk about, it's more of like a business practical step. That's a perfect question that every homeowners association, business, whatever it is, we, from a legal perspective, don't tell you what data to collect because that's your business. What do you need to run your business? But many times, a lot of organizations collect the data they've always collected. So the head person in front of them collected it, and think about how many forms you fill out in any given day that collect information that you think, why does this person really need whatever's being collected? So my first step would be, from a business perspective, as the question asks, think about what you're collecting and why you collect it. And if it achieves a business purpose, then you implement the things that Peter's about to talk about. If it's not a business purpose, it's just a legacy information, it's causing you risk and providing no value. So I would say immediately stop collecting that information and purge it from your system, because you have no idea how many breaches Peter and I have had to deal with when a bulk of the information that has created all of these costs and headaches that Peter's talking about is non-valuable information, meaning it might have been valuable to the criminal, but it had no value to the organization. They just never purged it and never thought, why do I even collect this in the first place? So I'll get off my soapbox and I'm going to kick to Peter. The 5 legal things that you could do to protect yourself from the information that you collect for your business purposes. What would your top 5 be?
Well, first off, just for why they were specifically collecting our birth date, it was we have a gym at our HOA and they only allow folks of a certain age, and so you had to give your birth date to prove that you were of an age to be allowed into the gym that we had. So that's the specific reason why they needed my birthday. 5 things. So I'd say the first thing, number 1, would be to have your vendor contracts reviewed by an attorney with the CIPP US credential. Angela and I both have it. We've both gotten it. It's kind of the industry standard at this point to say this person understands what they're talking about on privacy and data security matters in the law. Having someone like that look through a contract with a management company, with a payment processor, or any kind of third party shouldn't have too much investment, but it can have significant dividends down the line. So that would probably be the first thing I would say to do. Second, there are some basic technologies that aren't too expensive that you can implement that can go a long way to protecting information. They can keep it away from prying eyes of criminals, but also protect the organization from some kind of liability. Encryption is the first one that comes to mind. And for non-technical folks, encryption is a mathematical process that takes normal text and renders it unreadable to anyone who doesn't have the decryption key. And there are some states that have said that if your data is encrypted and it gets stolen, but the encryption key does not get stolen, that it doesn't trigger reporting obligations. Not all states have done that, and not many vendor contracts will make that distinction. So it's not a silver bullet, but encryption can be very helpful in kind of shielding an organization from liability. Another technology that you could implement is two-factor authentication, which is a technology that will send a code, or you'll somehow get a code outside of the password process, and you'll need to input that code in addition to your password in order to get access into the account. And both of those can be helpful. Two-factor authentication particularly will kind of alert you if someone's trying to get unauthorized access to your account. So third, just developing and reviewing your policies and procedures internally that make it so that everyone in leadership knows exactly what their role is in the event of a data breach. It can be incredibly helpful and useful when a data breach occurs, and can save a lot of money, that everyone already knows what their role is and they're just executing a plan. Fourth, I mentioned a little bit earlier, cyber insurance can be used to really great effect in covering the low likelihood, high impact events. Let me put a little bit more meat on that. I've heard from a lot of cyber insurers that a number of their clients tend to think that if they buy insurance, they can forget about the problem. And that's very much not the case, to put it mildly. Because then when they don't develop the policies and strategies or implement the technology that we were talking about before that are needed to reduce cybersecurity risk, they then get upset at what happens to their premiums or that there are caps put on their policies that they don't find to be enough to cover what they expect the loss might be. By contrast, clients that are proactive about protecting data but use insurance to cover the rare instance that slips through the cracks tend to be very pleased with the premiums and the caps that they see on their insurance policies. So making sure to not think of insurance, as something that lets you be complacent. It's a great tool, but it's not the whole toolbox. And then the last thing I might recommend for this group in particular would be bringing this up at an annual meeting. This will let you know where your residents, your stakeholders expect you to invest, what their expectations are for data security in your organization. If the residents are willing to accept a level of risk, then that can inform the risk management process that you'll go through. But if the stakeholders that an organization represents are particularly concerned about the prospect of their data's privacy, then that should also be taken into account when making these kinds of decisions.
We've covered a whole lot of ground. I know we've had a couple of questions, and we can always get into more detail. And we did allow for an hour. What we found is people typically have a lot of very substantive questions around privacy and data security. Our presentation was intentionally not very weed detailed in terms of telling you like all the requirements of NIST or any particular law. But opening it up to questions, I think Jen is going to let us know what questions have been asked, and we'll try to cover as much as possible.
Great, thank you both. So the first question is, why do associations or management companies even collect owner banking data? Shouldn't they get away from that risk and have owners work directly with a bank or a payment processor and keep the association and the management company out of the middle?
That's very similar to what Angela was saying before. We don't tell you what data you need to collect. We've seen that several do collect this. I know mine does. If it's necessary for your business, then we'll help you develop a plan to move that forward. But there's a process, a principle called data minimization in some of these laws that encourages you to collect less information if you can do so without injuring your business.
And outside the association, just generally when we talk to clients, that is something that we talk to them about. Do you need this? Because there's all sorts of payment processors that are more than equipped to meet the payment processing requirements and the industry standards, which can get very complex and from a technology perspective, difficult to meet.
Great, thank you both. And we did have a question come in that I think ties in nicely with that first question. So it is, what if you use an accounting program that's online? The association is placing the residents' information into the accounting program, and it's a program that they pay for. So I think the question is does the association assume that privacy risk for this information, even though it's being put into a third-party information system?
Yeah, and that ties in perfectly with what Peter was saying earlier. So the way privacy laws are designed is the organization or person that collects the information is the one that owes the obligation and has to comply with the law. But there are ways in which you can share risk, you can shift risk. So ultimately, yes, the association is on the hook because they're collecting it from their homeowners. But looking at that vendor agreement in terms of what that accounting program is offering, what kind of technology it has in place, that's part of your due diligence. In terms of from an attorney perspective, when we look at vendor contracts, Are there indemnifications? Is the vendor's company going to cover if there's notification? Who has the responsibility to act? All of that is usually contractually required, but this question is a great one because we often see that most people say, okay, well, I just pay somebody else to do it. And that's great, except you then also have to make sure that you ensure they have the responsibility that's going to help you comply with your obligations.
Thank you, Angela. All right, and it looks like we've got one more in the queue. So our HOA maintains a resident list of homeowner names, addresses, phone numbers, and email addresses. The list is shared only among residents, and the data is not posted on a website. The data is provided to residents as a courtesy for all to share for personal contact and information only. Is this type of data at risk given the intended purpose?
Yeah, so it'll depend somewhat on what law applies. And like I mentioned earlier, the law that applies is determined based on where a resident resides long-term. So if it's a vacation HOA and you have folks from all over the country, you might have a different answer than if it's just in North Carolina. But so when you're maintaining the data, whether it's in paper copy, whether it's in digital copy, the privacy laws are just going to, look at, okay, are they maintaining the data? Does it meet certain requirements to trigger obligations? And if those answers are yes, then you're going to have to comply with the laws.
And another way to look at it is consent. Like when you collect that information, so that doesn't always get you out of risk for so in North Carolina, if you had unauthorized access under this situation where you had a name, address, and an email address, that doesn't rise to the level of a breach. It doesn't trigger a breach in North Carolina. There are other states that it may. But then there's also in many states, did you consent to having that information collected? Did they undertake the risk knowingly? Did they know how you were going to use and, disclose the information? And so there's also the level of, you talk about disclosure for the intended purpose. If they knew you were disclosing it to those individuals for that intended purpose, then that's not an unauthorized disclosure. And so I know a lot of this is like gray and wiggly, but as long as in this situation for North Carolina, if those residents know that's why they're giving it to you and that you're going to share it, you're generally going to be okay.
Great. Oh, we've got one last one. Let's see here. What are the main laws to review for data security in North Carolina?
So there are a few. There's general negligence law where you have, anytime you're taking overt actions, you have to, act reasonably. But there's a statute in North Carolina called the Identity Theft Protection Act that kind of goes through the data breach notification process, when it's triggered, when it's not. So those two are going to be, negligence and are you acting reasonably, in addition to the North Carolina Identity Theft Protection Act, are going to be two of the bodies of law you're going to want to pay the most attention to in North Carolina specifically.
All right, I think that was all of the questions today. So thank you so much, Peter and Angela.
Yeah.
For those of you in attendance following today's webinar, you will be sent an email with a list of articles related to the issues discussed today, a recording of the session, and a link to sign up for Ward & Smith's community associations and privacy and data security alerts. We so appreciate you taking the time to join us today and hope you're able to take some of the information you learned and apply it to your own organizations. Thank you again, and this concludes today's webinar.